Okay, good morning. Welcome to Senate Health and Welfare Committee. Chair Lyons is with JFO at the moment. She'll be back here momentarily. But we're going to start with H661. It's an act relating to child abuse and neglect investigation and substantiation standards and procedures. We're going to kick off with testimony from Larry Crisp, Executive Director from Vermont Parent Representation Center. And floor is yours, sir.
Good morning, and thank you very much for the opportunity. Just so you know, this is mercifully one page. So the first is H661. The problem, H661 updates and improves a critical stage function, the investigation of child abuse and neglect. Parts of this function are some 40 years old and have long since outlived their initial purpose and usefulness, resulting in too many families wrongfully deemed to have abused or neglected their children, and undoubtedly individuals who have abused and neglected children not being identified as having done so. What H661 does to address the problem? This comes from an unprecedented 5-year cooperative effort between government and non-governmental entities. First, it adopts a better defined and more widely utilized standard of proof, determining if abuse or neglect has occurred, the preponderance of the evidence. It improves investigations, leading to more accurate determinations of abuse or neglect. It improves due process protections through consistent central decision-making, better notification of a substantiation, better record keeping of the notification, more realistic timeframes for appeals, and an administrative review process that is in sync with the Human Services Board. It improves the use of the Child Protection Registry as a public safety tool. And lastly, it reduces the number of people placed on the registry. The anticipated outcomes. First, more accurate and consistent determinations of abuse or neglect. Second, children who are being abused are better protected, while families are spared the trauma of wrongful substantiation. Third, streamlined investigations leading to more efficient use of state employee worker time. And lastly, fewer people listed on the registry, resulting in more people who are eligible to enter the workforce. I thank you very much for your consideration and hope for the speedy approval of this bill. Also, just to let you know, there are a number of changes that are going to be proposed, and the Vermont Parent Representation Center supports those changes. So thank you.
Thank you, Mr. Crisp. Before you go, questions?
Oh, that's right.
It's a two-way street.
That's someone else who's coming in to answer the questions.
Any questions? Thank you, Mr. Crisp.
Thank you very
Thanks for
much.
all of your work on this, yeah.
Well, thank you. You guys are the folks who are going to make the difference.
Very know about that.
Thank you.
You've done so much work.
I'm sorry I wasn't here, but I'll look at it later. Appreciate your time.
Ms. Rose?
Morning. For the record, my name is Amy Rose. I'm the Policy Director with Voices for Vermont's Children. Thank you for the opportunity to testify today. Considering where we are in this process, Voices would like to start by clearly acknowledging that we support this bill. It goes without saying that the Family Services Division of the Department of Children and Families is tasked with incredibly difficult work. Even at its best, this work happens within the context of conflict and pain. The tools available to ECF to create safety for children can be life-changing, and utmost care and respect is needed to ensure that their work is implemented with transparency and with accountability. This bill is a step in the right direction. The FSD employees I have encountered came to their field because they wanted to help kids. When we asked them to substantiate an 11-year-old, which is still possible within this bill, or put a single mom who is overcoming remarkable odds and truly loves her children and shows up every day for them on the registry, knowing that it will impact her current employment and could be the thing that tips the scale and brings her children into safe care. We create what is now being called a moral injury. When these injuries stack up, we lose staff. Staff we desperately need to retain. Voices appreciates this opportunity to reflect broadly, as we sometimes get lost in the details and forget to acknowledge why this work matters. H661 is before you, in part because UCF took a risk. They took the opportunity to reflect, to lean into criticism from the Parent Representation Center, and to see feedback as an opportunity for growth. Putting aside one's ego can be tricky for all of us, but when you are engaged in work that can literally impact the life and death of a child, it is understandable to defend what you have been trained to do. Believing in the process is essential to coming to work every day. Yet, we also know that we are our best when we are adaptable, and this bill represents that. When we ask our state employees to do difficult things, it is critical that they can point to a sound process. This avoids over-responding, and also is necessary for appropriate responses to stand the test of the courts. We also need to balance desire with consistent practice with our humanity and empower employees to be brave at the right moment, both systemically and when working with individual children. Voices appreciates that individuals who have been substantiated as a child have a carve out in this bill, and look forward to being a part of the next step of the process to examine if and when substantiate youth within our state. We understand that this bill is one step in a very long process. We also understand the frustration when the lack of capacity slows down important work. As we wrap up this legislative session, we must name the importance of the governor identifying the needs of his departments in his recommended budget. And we ask the legislature to ask as creative as possible questions, asking DCF what they would need to accomplish our collective goals without negatively impacting other areas of work. Voices see substantiation reform and registry reform as two distinct yet defined topics. While Voices is not aware of a validated tool that predicts risk of harm over time, there is a general agreement that certain types of harm are more likely to be transferable to the general population than others. Voices agrees that adding a second layer of consideration allows for the substantiation process to be responsive to its many uses while narrowing the scope of individuals who appear on the registry. Vermont's registry was established in 1992. Our practice cast a wide net for inclusion because the registry was primarily used internally in order to place kids who have already been removed for abuse and neglect. When looking to place kids who have experienced trauma, it made sense to be as cautious as possible. However, as the use of the registry expanded, the process for determining who was captured remained the same. Given this new, more expansive context, it is important to re-examine our approach to the registry and to ensure that we continue to minimize opportunities for harm towards children and youth, while also limiting undue burdens to those named on the registry. Vermont is not alone in this. The current iteration of registries as a tool to screen for employment has caused unintended and disproportionate. Congress links state access to critical funding that supports children and families, such as childcare, to employment screenings that rely on the registry. Yet states have a great deal of discretion about the process and standards for its registry. Therefore, the design and application of child abuse registries vary significantly across states. Registries can create a false sense of security for employers. Registries don't predict risk of harm. They simply share a slice of some people's background. When someone seeks employment in Vermont and a registry check is required, often the checks are only done within Vermont, which excludes a great deal of background information from other states, including traveling employees who often serve the most vulnerable. When they are required from other states, we don't consider the wildly different practices within those states, making the registry checks very inequitable. Anyone who was eligible for the registry before 1992 would not be captured on Vermont's registry. Voices knows an individual who should be on the registry based on current standards, yet all background checks have come up clean thus far. It is unclear how accurate they are or whether they are effective, whether there are effective systems in place to test their accuracy. If the state makes these changes, there will be inequities for folks who are currently on the registry. Long term, the state should consider an expedited expungement or an automatic expungement process for people who meet certain criteria. Note, this would take additional staff resources. With all of these contradictions and uncertainties, it seems clear that the tool we are using to name past harm may not be accurate enough to justify its impact on employment for some. Creating a more precise tool is a wise step in this reform process. In considering next steps, it is important to continuously ground ourselves in what the registry is and is not intended to do. As a structure, the registry functions separate from the response to a child who is harmed. A parent who has been substantiated for abuse can be placed on the registry, effectively serving to increase stress within the home without taking any substantial steps to protect the child within the home. To that end, the access to records portion of the bill does give me pause. We don't suggest making changes at this moment, but it's worth coming back to in the future. Voices hopes to be a part of a continued conversation about balancing the rights of the accused with the safety of the child. In domestic violence cases, the moment of disclosure and the time immediately after disclosure can be the most risky. Expanding unredacted access to records when there's still an open investigation shouldn't be done lightly. Identifying the child and children most at risk of harm and creating protections around them while simultaneously creating a fair and transparent process for the person accused of doing harm is complex. Voices will lean into our partners who are experts in this field and will continue to work with the department to offer opportunities to understand balance. These reforms are missing some critical pieces, which shouldn't hold us up in this process, but should be considered going forward. What are the best ways to reduce harm to children? One clear solution is to reduce stress. We know that economic stress does not bring out the best in people. It is also helpful to have safety plans for substance use and periods of instability. We need to continue to ask ourselves, how are we investing in our families? How can we move families first along? And how can we take responsibility for the safety of our children? We also know that people who pose significant risk in employment settings are sometimes allowed to leave one employment setting and gain employment somewhere else. This is a very sensitive topic to due process, which does matter. However, Voices must name the harm that comes when employees are permitted to leave quietly without treatment or accountability with letters of recommendation, enabling the harm to continue elsewhere. This is a problem worth addressing. We also know from Woodside that it can be difficult to hold folks accountable for their actions. If our goal is child safety, this is the problem we need to understand and address, and Voices looks forward to future conversations to address this issue. DCF might want to consider the language that it has used in the past, including when and how substantiation and evidence is used. One challenge that we have heard from the community is the evidentiary gap between the department and the courts. This can cause confusion, and more importantly, the evidence or information that DCF gathers is not permissible in court. The entire case could be dismissed as a result. Voices recommends increasing communication between DCF, the judiciary, DCF's training partnership, and the judicial college. As DCF develops their new training modules, we ask them to be inclusive of all the stakeholders they engaged in this process and to allow for flexibility as the policies and practice evolves. This is one of our top priorities at Voices, and we will continue to bring opportunities for reform to you in the years ahead. Voices celebrates the work that brought this reform to the legislature, and we also know that there is much more to do. Trust is built when decision-making is transparent. There are many thoughtful leaders within DCF and in Vermont who have the ability to shape the system in a way that holds us all accountable to child well-being. Voices would like to conclude this testimony where we began, by acknowledging that it is critical to give our state employees a space within their schedules to reflect and name when they think change is necessary. We appreciate the legislative process and the ability to agree and to disagree respectfully in hopes of better outcomes for children. Thank you.
Thank you. Thank you, and thank you for your work on this. It's important. I appreciate it. You did make some comments about improvements. Are you making comments to improve the bill, including the comments around communications with between DCF and other interested parties?
I don't think it needs to be listed in language, but I just wanted to name it. It's
right.
a commitment to the next year and a half before rules go into effect. And I do think one of the suggestions that you'll likely hear is an opportunity to come back before the legislature with a report before significant changes are made. And I think that could be an opportunity to change language if needed.
Okay. And then you talked about evidence, and I know that DCF is going to be talking about information, and we'll be talking with our Ledge Council about the distinction of two terms. So, but your understanding of evidence versus information at some point would be helpful. We won't ask you to do that now, but okay, it'd be helpful.
Thank you.
You used the term judicial college. I'm wondering how that, I think it was under the section of substantiation. I'm just curious. I don't know what a judicial college is.
So there's opportunities for judges and folks who support the court process to receive training as well.
Oh.
And
That's
I think within particularly the substantiation process, there is a disconnect between how the court sees DCF's role and how DCF sees the court role, particularly when it comes to cases of abuse within like the custody visitation process. And so it would be really helpful to have all the stakeholders talk and have shared language and shared understanding around how to get all of the information necessary in front of the court so that the judge can make the best decision possible.
Good.
Other questions?
There's a state judicial college and a national judicial college. It's
Okay.
a place where judges go to get trained.
Okay.
That kind of ties into the DCS training unit, just having opportunities for all the folks who are supporting each process to know.
Makes sense. I just didn't know what it was. I don't like things to pass over that.
Okay. Good, thank you. So we have, three of you, actually, there are two of you here. It says someone up. Okay, we've got three of you here. Thank you all. What we're going to do is to introduce ourselves, and then I don't know whether you have an order you want to go in, or if you want to testify together, so you can think about that while we're introducing ourselves and start here.
Good morning. I am Martine LaRocculic. I live in Burlington and I represent Chittenden Central, which is Winooski, Essex, Colchester, and Burlington. Nice to see you.
Good morning. Dave Weeks. I live in Proctor and I represent Rutland County.
Jenny Lyons, Chittenden Southeast. Thanks for being here.
Senator Terry Williams representing Rutland County. Thank you.
And I'm Senator Ruth Hardy from the Addison District.
Okay, so how are you organized? Are you coming up individually, or do you have something to offer collectively? And who's in charge first? Who's going first?
I think Jennifer Micah is general counsel for DCF, who is
Okay,
joining us virtually, and I think she is going to start it off.
all right, that's terrific. Thank you. All right, Jennifer, welcome. Why don't you introduce yourself for the record and we'll listen to what you have to say.
Good morning, Senator Lyons and members of the committee. My name is Jennifer Micah, and I'm General Counsel for the Department for Children and Families. First, I want to say thank you to Larry Christ and the Vermont Parent Representation Center and Amy Rose with Voices for Vermont's Children. I think that those two people working very closely with from DCF, Nancy Miller really has been critical in working with those partners to get where we are today. And I just want to make sure that that is called out. There are two main things happening in this legislation, as Larry and Amy mentioned. First, the technical changes to the statute around timeframes, video conferencing, and the mailing of notices. We've worked through a lot of details with VPRC, and I think that we have come to agreement on all of those. And the second big change is the change in the burden of proof, which moves from a reasonable person standard to the preponderance of the evidence standard, which we think is a fairer standard and more clear for our staff when they have to make a determination about the weight of the evidence that they are reviewing. We have provided to the committee a document which provides a number, I think about 13 different technical and substantive changes to the bill. Most of them are technical, and it is my understanding from Larry Christ and Amy Rose that those changes are all agreed by all three of us. And I'd be happy to start walking through some of those if you'd like.
I'm looking for nodding heads. I see nodding heads. This is helpful. Thank you. So
Okay.
if the technical corrections are agreed to, why don't we move to the substantive? And when we go through the bill with our ledge counsel, we will again look at the technical recommendations.
Okay. I will note that I believe I put the information piece. I heard you, my ears perked up when you were talking about information versus evidence, and I did put that under technical. So if you want to talk about that, we could talk about that, because that's the first thing on the list. And then
Go ahead and talk about that, because that is that might be.
Okay. Yeah. So when we were thinking about this, it was really about, when an investigation occurs, you have all sorts of information that comes in front of the investigator. And it's really about which pieces of information are important for purposes of proving the case or not proving the case. So the fact of the address of where somebody lives may not be a substantive piece of evidence, but it might be it might end up being it might be evidence in one case, but not another case. So it's really about how you use the information and which of it becomes evidence for purposes of proving your case. So this is really, we're saying, we're asking that in the intent section where it talks about what let me just pull up let me see if I can pull up the bill so I can make sure I have the language in front of me. The language in 661 provides that under the this is under the purpose section. So that may be also why I put it under a technical change. So it's ensuring that the Department for Children and Families efforts to protect children from abuse and neglect. The department also ensures that investigations are thorough, unbiased, based on accurate and reliable evidence, and adhere to due process requirements. We're asking that that be changed to information, because that is about the investigation itself. It's about the worker going out and accumulating information. And then when you actually create your report, that becomes evidence when you go in front of the reviewer and when you go in front of the Human Services Board. So it's not all evidence, not all information is evidence, but all evidence is some sort of information.
That's really helpful. Thank you. Go ahead, Senator.
I hear you. I like the way you just phrased that, but I'm curious. A report doesn't seem like it's evidence. A report seems like it's information. The evidence is the things that the report is based on.
Right. I don't disagree. But the intent section is talking about what the department should be doing, right? The intent section is about ensuring that the department does a thorough investigation. And so by changing it to information, I'm thinking about what it might feel like to be a worker. You don't want to be thinking about what you're getting as evidence until you actually get all your information and then you're sifting through it. So when you do the report, you're putting everything in the report that is both supports and doesn't support the allegation, and then from that you come up with a decision about whether you think it should be substantiated or not. So I think the use of the word information just allows the worker to have a broader view of what's coming to them and what they should be thinking about. I don't want workers to think, oh, that's not really going to be evidence, so I guess I better not include that. I want them to say, that's information that I need to put in my report and think about when I make a decision.
Okay, excuse me, I understand that. Excuse me. Can you, the specific you're saying is on page 2? I'm just trying to find in the bill.
Yeah, it's subsection 6 of the intent section. On page 2 of the unofficial version. I should have noted that in our memo and I didn't.
Oh, thank you.
Just because I like getting.
We are working from the unofficial version.
All right, thank you, Ben. Our council pointed it out to me. I got it. Thanks, Jennifer.
Okay. Are there any other questions about that?
No, that's helpful. Thank you. And it is in the intent purpose section.
Okay. And then did you want to go down to the substantive section?
Yes, let's do that.
Too much else in the technical piece unless the other parties have a concern about them. Okay, so going down to number 11 on the sheet.
Wait, hold on a second. I think there might be a question about another of your technical.
Yeah, I'm trying to, yes, number 4.
Okay.
The changing full to schedule. I understand why you would want to do that, but I'm a little worried that scheduling something, you could schedule it like 3 months in advance and then technically you've scheduled it, but it could delay the process a lot more.
That's true. And I put this under technical because we thought it was we thought it was something that the House had agreed to and just never made it into the draft. That was the understanding of VPRC and DCF. That's why I put it under technical. I see that you're making the substantive argument, you're
Yes.
making the substantive concern that maybe you don't want that. And I understand that, but I will say that, and Kathy Clark can speak to this a little bit more, but getting these held can be very, very tricky because there are so many different variables as to why a hearing might move forward or not move forward or be able to move forward. So I don't know if you want to talk to Kathy about that a little bit. But we are having a lot of trouble getting things set in that time frame. So we're looking for some ability to expand that a little bit.
Yeah, I mean, I just see that, oh, I'm sorry.
I was just gonna say, that this is one that I would want to have a discussion about. Because I agree with, Senator Hardy that if you take away that 60 days, it could be forever. So there has to be a date certain or a time certain within which this is not only scheduled but held. So let Jane comment, Senator, no, I'm sorry to interrupt, but you can go ahead after that.
Yeah, no, go ahead. if you want to.
I'm Catherine Clark. I guess I should say I'm the director of DCF's Commissioners Registry Review Unit. So thank you again. I echo what everybody has said. Really appreciate the opportunity to be here. It's okay if I sit here too with the committee.
Yeah, I just
rather than
wanted
come
to
up
give you
here
more
now.
space.
Yeah, so if I can just provide a little bit of background about the registry too and what my role is, that might help as well. So the registry was created.
Well, come on.
Sure, that'd be better. Okay.
Yeah, because we're gonna get the background that we need
Okay.
to understand something.
Okay. All right, so the registry was created in 2007 by statute. And at that point, it provided an opportunity for independent reviewers to come in and take a look at substantiated allegations and to determine if that was the correct decision under law and policy. So it established a unit, and part of that, the original statute was that those hearings be held within 35 days. So we now, if you look at this many years later, the registry went back to 1992. So in 2007, there were 15 years worth of registry records at the time. And it was envisioned that these reviews would take place and that after reviews had happened and a name had been placed in the registry, individuals could also come back with their petition for expungement of their records. So it's a little different. You'll notice in what you've got in front of you, you'll see verbiage sometimes looking like it's redundant and being repeated. That's why it's dealing with part is the review, part is the expungement. And the expungement decision is made by the commissioner. My point in saying all this is that we now have, here in 2024, we're looking at records dating all the way back to 1992, which is not 15 years anymore, right? We're dealing with 30, I'm not so good with math, yeah. So our workload has increased tremendously. We do try to get the reviews out expeditiously. It doesn't benefit us to delay it because until a review is scheduled and upheld, then a name doesn't go in the registry. So our focus is child protection, getting those names in the registry if the substantiation is appropriate. We also, though, in dealing with expungements with 32 years of registry records, are seeing a lot of petitions for expungement. And we are statutorily required to expedite those petitions that are employment related, meaning a job is being held up because of registry placement. So it is a constant shuffle in our unit for how we get these things scheduled. We also find, I'll say the majority of our individuals who ask for reviews or petition for expungement are not represented by counsel or VPRC. Many are, but the vast majority are not. Getting in touch with individuals who, when they ask for a review, give us their mailing address, their phone numbers, and their emails, but still getting in touch with individuals and getting these things scheduled can get delayed. Our process is very different from family court or criminal court cases that may be happening contemporaneously. So if they have a court conflict, then we get bumped down the road. If they have a sick kid, we get bumped down the road. And we try to be very agreeable and flexible in scheduling because these are important. And we do want them to have an opportunity to have these reviews. So if it means continuing a little bit longer, we do. And so my point is in addressing your concern, if you're ready for that. We figured we're trying to find a way to say when a request comes in, we process it and that we figure out what they're eligible for. They may be on there for multiple substantiations, so we need to figure out what they're in there for. If they're eligible for review, if they're eligible for expungement, we gather that information, we let the individual know, and we explain we'll be getting the investigative documents together. We have to go back to them by law, get them out to them, and then get it scheduled. So we're communicating that with them. And then it goes to our redactor, and then it goes to our scheduler. And our scheduler is reaching out right now. So we are getting in touch with people quickly. But to your point, the scheduling is not happening within 35 days. So that is, it is something, again, that we strive to do. It doesn't benefit anybody to delay them, but this is language that would enable us to keep that in focus, to get these out as quickly as we can to proceed.
I mean, it's already being, moved to 60 days and then the scheduling language potentially moves it way out. So I do think it's a substantive change. It's not technical and it's concerning to me. I hear you on everything, but.
Yeah, and I'm surprised the House agreed to this. This is, the House agreed to the change that you made. And Amy, you want to comment? Why don't we do that? Because this is our
Well, I
day for this.
appreciate the opportunity to comment. I agree with the concern of making it quick. The reason why Voices supported this is because I think that the department is responsible for the scheduling. They're not responsible for having people show up and be able to hold the hearing. And what we hear from folks in the community, some of these individuals are living in hotels. They're really hard to, it can be really challenging to work through this process. It's a complicated process. And so giving some flexibility for folks who are experiencing a lot of trauma on their own to extend beyond 60 days could also be helpful. And so I think it's important to have a firm deadline for when the department needs to do their part of scheduling, but then also to allow for flexibility for sort of all the life experiences that happen to somebody that needs to prepare themselves and show up.
Yeah, so, I mean, what about if we change it to schedule, reducing the number, the 60, so that they have to schedule something, but
Earlier.
it could happen
So
earlier.
put that down for a discussion point. We'll do that.
And I think Larry might also have a position.
Okay, Larry.
Attorneys often want longer. I'll add that too. Attorneys often want it 6 months down the road.
Oh, okay.
To that point, individuals, as this court pointed out, most people are not represented. They do this themselves. It is a complicated process. And in some cases, it takes them a month or more to fully understand what it is they're supposed to do. Then if they want to try to find a lawyer, which is not easy to do in these cases. I know some people who call as many as 100 attorneys. Not gotten anybody who'll take one of these cases.
Whoa.
Wow.
There are reasons for that. There's not a lot of money in it. So that's one major issue. The other issue is because there's not a lot of money in it, there are few attorneys who know how to do them. And they will be honest about it. Say, I don't know how to do one of these cases. And so what we have found is by the time the individual, the regular Vermonter, figures out what it is they need to do, if they're going to do this themselves, then they have to find the rules, they have to find the law, they have to find all of these things themselves. It is not enough time. It just isn't. Frankly, I find that it takes about 90 days by the time someone gets a notice until they can figure out how am I going to defend myself? And how do I gather the information? How do I get a hold of the witnesses and line them up and make sure that their timing works? It's really a complicated issue. It's very hard on the department side and it's very difficult on the average Vermonter side. So that's the reason that we compromised on a time of saying 60 days to prepare and then get a notice as to when your hearing is. So that they can, as an example, if they have 3 witnesses, they need to find a time with the department when those 3 witnesses are going to be available. They can't control the witnesses, they can only try to schedule them. And then the department then tries to accommodate those schedules. So
I can I can relate to the finding the witnesses at the right time. Thank you all for these comments. Looking at it a completely different way, from what I think we were looking at. The
Yeah.
language, yeah.
That's why we're so appreciative to be able to come in here.
Yeah, no, this is great. Senator Weeks.
Thank you. So Ms. Rose was speaking just a moment ago and you were speaking about, difficulties of contact because they're living in a hotel, and then you said it's hard to, and then your sentence faded off and jumped into another topic. They're hard to what? They're hard to contact for notification of meetings and such,
It can be hard to get all the information necessary and to process it and to be prepared to show up in a way that will make your case.
Okay, so can I ask you specifically?
Yeah.
The notice criteria that's in the bill, is it sufficient? Is it strong enough that I think it's an email or a call, but not a contact, I think it's personal contact is the term. I'm not sure if that's right or not, but are you satisfied that the methodology is adequate?
I think it's tricky. I think that given our current resources and given the way it's designed, I think that some people have an active address and that's the best way to contact them. For others, it's really is a phone number or email or a different method. I do think there are other states who have looked into more due process and getting individuals representation earlier on to help navigate this complicated process. And I think that could be something to explore long term. I don't think we're there yet with this bill, like we need to take the next step. But I do think that this will allow for more conversations around making sure that our process is accessible, right? That it's something that folks can navigate and that people feel satisfied when they get to the end of it.
Okay, all right. So are there any other of the technical recommendations that you've made that either the committee, do you have any, as you're looking at the technical recommendations that are here? But I would like to move to substantive. This is on our webpage. It's from DCF and my iPad is not here, so I have the luxury of printed documents.
Oh, Nancy numbers.
Yeah. It's sitting. Okay, why don't we move on to, what we'll do is, let's go to substantive changes. It seems like that might be the place for more discussion. We can go back to the recommendations that you sent us for technical changes after we've done that. So this is what we have time for, and this is great. So, and let me ask you the question, as we're going to substantive changes, are these changes that are agreed upon with all the parties who are here? I see the heads shaking. That's very helpful. And then so why don't we look at them from your perspective so we understand what the reasoning is? I see everybody shaking their
Sorry,
head.
yes, Amy too.
Yeah, Amy and
I
Larry.
can clarify that a little bit. Basically, I think that we wouldn't have proposed all the language, but I think that it makes sense. And there were some changes that were, negotiated quite a bit before this process. And I think that where we are is like the right place for this bill at this moment. It's hard to see that, the amount of time before some of these changes go into effect. And I think it's really important to get it right. And with the current staffing capacity and the commitment to engaging so many voices, I think it makes sense.
Okay, thank you. So who's gonna walk us through the substantive changes? And then after we've done that, we can turn to Ledge Council and talk about how best to improve the bill.
Do we have that document?
I think it's on our.
It's Nancy Miller's,
Nancy name. And I called you Jane. Did I call you Jane?
I'm Catherine. You may have, I didn't catch it. I'm Catherine, she's Jennifer, so
She's
it's,
Jennifer.
you know.
And Nancy
Nancy
is here.
Yes.
Thank you. And then somebody said the.
Today's.
Here you go. I'm gonna hand these out so everyone has a written copy. Might be easier for you.
Jennifer, okay, she's done.
There you go. Thank you.
Thanks.
Hey, Ben, you want one of those?
I might gotta pull.
You got it. Okay, good. All right. So go ahead. Please.
I think Jennifer is doing this.
All right, Jennifer, you can stay here. You may have questions.
Thank you. So the first substantive change, number 11 on your page, it's about, so right now the registry review unit has reviewers, neutral and independent arbiters with no prior involvement in the original investigation. And they have a meeting with the alleged perpetrator, and they go over the investigation and offer the opportunity for the person to discuss what happened, raise any additional information that might not be in the report, might be confused, things that they might want the reviewer to reconsider. And then the reviewer makes a decision based on that, any additional information the person provides, as well as the investigation itself. The language that was added by the House in this piece was around the tier level. And the tier level is based on the level of risk a person presents to the community in the future. And so the language that was added asks the reviewers to make it, to be able to review that piece of the investigation recommendation. And we would like that not to be included because our reviewers are not at all skilled in making determinations about risk level for an individual. So
What
this
number? Can you tell me what number?
Number 11.
Number.
Oh, in 4916A.
I'm on pages 8 and 9 of the bill.
Oh, okay, yep.
Subdivision 5, thank you. Okay, that's good. So it's on page 9.
Yes. So we're
Line-
asking that, we're just asking that it stay the same, that the change not occur around the tier levels, because our reviewers are really not capable of doing that, what they're asked for in that section.
Okay,
And we do need to talk with our stakeholders about tier levels, and we intend to do that when we do the rulemaking. But this would be putting the cart before the horse, and our review, we already have a difficult time contracting with a sufficient number of reviewers. This would make it even more difficult for us.
okay, thank you. You can just keep going. We're
Okay.
just getting information, and when we have our ledge council up, we'll go through the final discussion, and knowing that everyone in the room is in agreement helps us, but we do need to understand it.
Yes. So number 12 is substantially the same. It's just in a different section. It has to do with oh no, sorry. Number 12 is about expungement. So you don't determine tier levels in an expungement. That's already determined at the initial
Can
review.
you tell us, when you start doing this, we are totally blind to what is here. So what we need to do is a page number and a number that we're looking at, please.
Okay.
That
So
would be-
the page number of the bill, you mean?
Yes, please, yeah.
The page number of the bill is page 11 and 12, lines 20 through line 2 of page 12.
Huh?
And just those. Separate.
No, we'll figure it out, sorry.
It's the bottom of,
Sides 20 and through line 2, and that is related to, just tell us what it's related to, so we have some notes. Designation levels comparable with what we just looked at. So this is consistent with what we just looked at. Got it. So now we can just move right ahead.
I was just noticing that maybe I had that mistaken. Hold on.
Yeah, Stasia, let's see that. Okay,
Lines.
now we're moving on to page 18.
So we are,
Page 18, number A7. Is that what
Right.
we're on? Okay,
yep. So we're asking to remove this section into the rules. So this was added to be included in the rulemaking that we're going to be doing around these issues. And we did not want to, we're not sure we can do this yet. This whole, the idea about how you substantiate, for lack of a better term, how you substantiate and not place somebody on the registry.
Uh-huh.
And so we wanted that removed because we don't feel like we are going to be ready to do that in time.
So, okay, my question here would be, if you're not ready to do this, it requires some kind of, maybe reaching out to interested parties and working with folks to make decisions.
Yeah.
Would it be preferable to just direct you in preparation for developing rules to reach out to interested parties and discuss these, all the information that's here between 7 and 10? I'm thinking this, I will have the discussion as a committee, but I think it would be helpful for you to think about that as well.
Yeah. Okay. Well, yeah, we could think about that. Nancy, I don't know if you have any comments about that. I know we are working daily with our stakeholders, so go ahead, Nancy.
Between 7 and 10, sorry,
The numbers that are here.
Oh, the numbers are, okay. I think, so what we are proposing to do, and it sounds like what you're suggesting is that the statute direct us to do, is reach out to stakeholders. And I think the stakeholders with this particular section, it's so important. So we're thinking about the folks who rely upon the Child Protection Registry, such as the Agency of Education,
See that?
childcare centers,
Yeah.
A lot of AHS entities. And so, yeah, our concern was that to be ready to formally introduce rules by September 1, 2025 was unrealistic, given what stakeholder work really looks like.
Yes, okay.
And so what we're proposing is that we would be prepared to provide a report at that time to the legislature.
So it doesn't have to be a report, it
2025.
could be a presentation, which makes things a lot less complicated.
Certainly.
Okay, so we'll think about that one. And you've got the language here that helps us, so I appreciate it. Go ahead.
Do you mind? I think you were talking about a different section just now.
Talking about page 18, 4922A7,
Yeah.
and then,
We're deleting the rules required about substantiation categories. But you are talking about a report back to us.
Right, that's in our, the document that we provided with our recommendations.
Mhm.
So it's recommendation number 13.
Oh, to do a report instead of doing this, I see.
Presentation.
If I may, we're talking about creating a central registry to review the investigations before they go, before they're finalized, in order to create a more systematized assurance of quality and accuracy. And so that's going to take some work. And so these rules would be premature. The rules some of the rules make sense, but some of them would be better to wait until we have our discussions with our stakeholders around how best to create that centralized review process, what kind of staffing we'll need. But we think that would be a really, really positive step in ensuring quality improvement, which we've had trouble with given all the staff turnover and difficulty with the cases. So I think that's what we're looking for here overall, is an opportunity for more time to do the underlying work with stakeholders before we have to engage in rulemaking, and not to push the rulemaking on some of these issues prematurely.
Okay. One thing I would just note, Madam Chair, is that the time when they're suggesting the reports, the legislature's not in session.
a week,
So-
that.
it would have to, if you're requesting a presentation, it would have to be,
We can sort that out. A report is a written document. It might be useful to have that written document as a record, so we'll have to talk about that and that your preference. What is going to be most informative?
I always think that a written document, including a presentation, is most helpful for the people hearing the presentation. For the folks who like to do a little bit of research in advance of hearing the information.
Okay, all right, so we'll.
yeah, and also out beyond legislators, like the other stakeholders, to have something in writing from the department, I think would be really helpful. It helps hold them accountable to the work that we're asking to do.
Okay. All right. Let's go to,
That is the last one on our substantive changes.
okay, that was 7 and 9 on that page. What about 8 and 10? 8, 10 stays. 8 is, are the appeals and notice procedure. We're not gonna include those in the work that you're doing outside. Or do we want it all together? Might be helpful to have a conversation. It will help you in rulemaking if you have the conversation up front, and when you have the public engagement process, a lot of the work will be done, so. Why don't we
Yeah.
can we lump?
Yes, I
Well,
think that's a great
I'll
idea.
look at number 10 with our ledge council and determine if that one should be lumped or not.
well, they already existing rule,
Yes,
that they have to make, so if they're saying they can do 8 sooner than later, I think we should have them do that.
yeah, okay. That makes sense to you?
I will have to defer on that. I'm sorry, Madam Chair, to Nancy.
Okay.
The FSD.
Which one is number 8?
Rules
Sorry.
require notice and appeal procedures for alternatives to substantiation.
That should be included that's part of the work that we need to do with the stakeholders.
Okay, so
So-
The alternatives to substantiation is absolutely, that's it.
7, so please let us know what numbers then might we include in that?
I think you're right, Madam Chair. I think it's 7 through 9. We still need the rules. We still
Okay.
need 10 to. Well, actually, I'll need to go back and look at number 10, the rules implementing 4916C and E.
Yeah.
Let me see, but maybe we can have a.
I think based on the changes that are being suggested, the reference to 4916 sub E probably should be removed because that's talking about the protection levels implementation.
Yeah.
So it's sort of a belt and suspenders cross reference because it was addressed in that earlier statute. And it's also mandated in rulemaking here. So just to keep them reconciled.
Now this will, yeah, we,
Yeah, I'll go with
yeah,
that.
good, okay. All right. Okay, and you can let us know if there's differences. We're gonna go through with ledge council. We'll continue to have our conversation. Good. Thank all 3 of you for being here. Appreciate it. It's helpful. And so I know we're supposed to move on at 10, but I'd like to take some time while our heads are current to move into with Ben. And we can have Kiki let Michael Chernick know that we're behind schedule, which is highly unusual in the legislature. Ben, why don't you come on up and why don't we go through and do that?
Morning.
Good morning.
For the record, Ben Novogrosky from the Office of Legislative Counsel. I'm happy to assist and help explain anything that I need to. I know that there's I think, General Counsel Mike did a good job explaining the difference between information and evidence. I can elaborate further if you'd like.
Please, yeah, we'd like you,
Sure.
yes.
Yeah, I mean, so I think the general concept is, and I think the analogy is good, is that not all information is evidence, but all evidence is information. And so evidence is really anything that has a tendency to prove or disprove a fact that's relevant to the case. And so that evidence, is then there's weight assigned to it. So how significant or probative that evidence is. So sort of those two stages, right? Information, and then any of that information that has a tendency to prove or disprove a fact that's probative to the allegation would be evidence. And then within that evidence, there's sort of a determination of the reliability and credibility, and therefore the weight that's assigned to the evidence that's gathered, that's used from the information that's gathered. I don't know if that clarifies or
That's
makes it more,
clarified. That's for me.
more complex.
While you were talking, I was thinking about, suppose I were involved in a case like this, I wouldn't understand one word you said. Unless I were the lawyer, but I do understand it just because we've been mixed in with this for so long, but, yeah. Okay, so,
I'm happy to answer any further questions on that.
any questions? So, my general question is related to the document that we have from DCF that it seems like everyone has agreed to. On the non-substantive or technical pieces. I'm thinking that we could ask for you to integrate those into the bill.
Yes, and that's relatively easy to do.
Okay,
Yeah.
and then the one area. And then similarly with the substantive changes. And then talking about what are the last discussion that we had with regard to the rulemaking and having some kind of activity by Family Services and DCF folks, to bring us a report on numbers 7 through 9 on page 18. And that would be reaching out to stakeholders. They've listed some, including AOE. But there would be others as well, some sitting in this room. So AOE, DMH, CDD, AHS, well, AHS, right? And then other interested parties, I guess we would want to have. My suggestion would be that we have some language in there that brings the report back with ultimately a presentation to committees of jurisdiction.
Yeah, so a written report and a requirement to maybe testify about the report for
Yeah,
committee
presentation.
presentation.
It's a reminder to us that we need to follow up. Now, my question of the committee is this: we've heard Rose has been saying, well, that we'll leave that for another time. We could continue to look at these issues. I don't want to muddy waters here and pile on work, but do we want to add anything about to this process for recommendations for further legislation related to this? It's an open question right now for the table. And then after that, I'm trying to look around. I see concerns on some people's faces because I know there's a lot of work involved in just what you're doing here, and I don't want to add on to it. Or should we just leave that? Let's leave that suggestion. Let's leave it. I won't.
I mean, another option is that you could put in sort of language that,
Any other recommendations?
yeah, like any recommendations, if they exist or something like that, where it says, if you've gotten to the point where you can make those legislative recommendations, great, we'll accept them, but it's not mandated.
Okay.
Just.
I don't, if once you do that, then I think I see Amy Rose and Larry coming in with all these great ideas. In the meantime, DCF is thinking, wait, let's just get to the information that we need to work on for the rules, so that becomes problematic. Let's think about that. Sure. Everybody's working hard for this.
Yeah, I feel like everyone's working really hard, and I feel like everyone in this room understands the legislative process, and I would imagine they've given it a lot of thought, and
This is it.
I don't want to speak for them, but
No, you speak for yourself.
speak for myself.
Okay. Now, I'm just looking around, okay, Senator Weeks.
No, I just want to, I have some questions, but I want you to sort of continue with.
Now, I was gonna start going around the room, so I want your questions.
So in testimony, previous testimony, the last time we had, you touched this bill, there were, to me, two questions. First one is on, and kind of throwing it out to, you have all the folks in the room, so it's a perfect opportunity, a redaction. I'm wondering what information is redacted from whom, what, when and why? And I just, not that I object to it, in the first testimony, it didn't flow very well. And I'm curious if there's anybody that can address that.
I can address it as far as the substantiation process goes. When an individual requests a review and comes to our unit, they are entitled by statute that we're not addressing in this bill, but the statute that would remain is that they're entitled to the investigative record. And what that means in our current database from 2003 going forward is the intake report as it comes in, the investigative activities summary, and the case determination report. And those are the documents that the Family Services Worker collects all the information and considers it as by policy. They're supposed to consider all information, including supportive and contradictory data. And that's where they do it and cite their rationale for substantiating an individual. So if they request a review from our unit, we're by law, again, in the statute, required to provide only redacted copies to them. So
To them,
to the substantiated individual requesting review.
substantiated.
So that makes sense.
Explain who the substantiated individual is.
So that's when a report comes in and they substantiate allegations of child maltreatment. They say they'll identify the victim or victims and they'll identify the perpetrator.
Okay.
So it is that we refer to them as often as a substantiated perpetrator, substantiated allegations though, and that is the identified perpetrator. So they're the individual who's requesting a review so that their name does not get placed in the registry.
Okay.
So we provide them with those redacted investigative documents.
What's redacted from them? That's what.
So things by law, so the reporter's identity and information will be redacted. They redact HIPAA required things, confidential things that would have to do with, because for instance, we often have out of home perpetrators. So we could have individuals who are not related to the family at all and know nothing about this family. And in the course of the investigation, the family service worker may have learned all kinds of information, medical information, educational information, mental health information going on with this family that maybe isn't even dealing with the identified victim or the identified perpetrator. It's just collateral. It was gathered as part of this investigation. So when that is being turned over for purposes of this individual contesting the substantiation, those things with a mind towards protecting victims' rights and safety purposes in domestic violence situations, obviously.
I was gonna say, if we had an example of domestic violence,
That's
that
right.
might help.
That's right. Yeah. So in those cases too, to protect individuals there who might be at risk, things like that.
Good.
So this is public information for
No, this is completely separate. Thank you for bringing that up. I should have clarified this to begin with. This registry is not public. I tell people in these review meetings, your nosy neighbor cannot sit down at their keyboard and type in your name and find out if you're on the registry. The commissioner is by statute allowed to divulge a registry record in very specific circumstances. And one of those is to a potential employer, if they would like to be hired or volunteer with an organization that is involved in the caretaking of children or vulnerable people or providing transportation for them. And the individual then has to give the employer permission. He has to consent that you can call the registry and find out. So it can be disclosed that way, but otherwise, no. And so it's very separate. You'll hear like there could be the related criminal cases, there could be a related Chin's petition in family court talking where they're considering perhaps removing the children from the family. This is completely separate. This is really just dealing with whether this treatment occurred and if this individual is responsible.
What if the accused, and I understand it's difficult to get legal representation at times, as Chris pointed out. If they do gain legal representation, is there representation? They have no different access
No.
or improved access.
No.
All right. And then the second question, again, kind of throw it up as a softball, see who catches it. So, confirmed contact do you have any kind of, what are the challenges of contacting the accused in the case of an allegation? There was some hesitancy, it's not current policy to do personal contact. Is there any history of contact?
Well, I would offer that the confirmed contact language is really for the investigator to confirm that that contact is correct. So as an example, there are some cases where an investigator will look at the intake report and see the phone number and the address, but they never ask the person, is that phone number or address accurate? And in fact, the report was made by someone else. So they go through a process and only to find out later that they didn't really have the person's address or their phone number. This is really for the investigator to make sure that they gather that information.
Okay, my real question is, it's what I gleaned out of the first set of testimony was that there's not a requirement to personally contact the alleged that they've got a case against them. And that's what I took away. Didn't sound right, but can you just explain briefly that process?
But let's turn to,
Yeah.
let's turn to family services.
If you're talking about during the investigation, so when a report is accepted as a valid allegation and is assigned to a worker in a district, then that worker absolutely must make every attempt to contact the alleged perpetrator and let them know what the allegations are against them and give that person an opportunity, to participate in an interview and tell their side of the story.
Okay, any history of having challenges in that contact?
Yes, absolutely. Yeah, there are challenges to that. I mean, there are individuals who would prefer to not engage in the process at all. There are individuals whose attorneys advise them to not engage in the process. Those are not the majority. I think the majority of people, if we can find them, I think we also sometimes run into challenges. As Larry pointed out, there are times when the reporter, the person who's reporting the concern doesn't know where the alleged perpetrator resides. And so, sometimes there's a challenge in locating that person. But we do make every effort, we search databases. If that person has an involvement with Department of Corrections, we might reach out to see, or economic services to see if we can try to find them. So there are a lot of challenges, but I think, I don't have the statistics at the tip of my finger, but most of the time, the alleged perpetrators are contacted. And then, of course, we have our investigations that occur as joint investigations with law enforcement that are also criminal investigations. And when that occurs, we allow law enforcement to take the lead and we kind of trail behind and share information with law enforcement and vice versa.
Good, thank you very much.
Good. Senator Williams, you had a question? No, good, okay. Terrific, all right, so committee, would you like to go through the bill one more time, or shall we hold off and have Ben come back with the recommendations and put into the bill changes that we've talked about? We do that?
Question, will this bill be going through judiciary?
No, probably not. They may want to look at it.
Yeah, brought that up in the first testimony. Curious why, because the allegations here are pretty significant. I'm wondering why they wouldn't want to take a look.
So this is and if I may.
Senator.
Sorry.
Senator, let's counsel Ben.
Let's go. I mean, I'll take a promotion, but it may not be deserved.
Well, you never know if it's a promotion or demotion.
But to that point, so it's a good question because as you're indicating, Senator Weeks, these are serious allegations and with serious consequences. But this is a completely administrative process within DCF until you get potentially beyond the Human Services Board. But to that point, there's almost two levels. So there's the initial substantiation, there's the potential review, and then there's the appeal to the Human Services Board. So I think the short answer is that it's a quasi judicial process that happens within an administrative agency or to another administrative body. And therefore it doesn't involve the judiciary.
If there's evidence of a crime, you know, yeah, then it could.
Yes, but that would be kind of a parallel track and sometimes they can go alongside, play out. Oftentimes an investigation may wait until the result of a court case, or vice versa. It's really kind of fact dependent.
Thank you.
So. Any other questions for Ben? So what I think we'll do is we're gonna come back to this. Kiki, we have it on Tuesday. We have it on Tuesday. We can look at it Tuesday and Wednesday next. And hopefully Tuesday won't be too long on the floor and we'll be able to go through a new draft of the bill and then we'll be ready to consider voting it out sometime midweek next.
So just to clarify, I'll incorporate all the technical changes and then as far as those substantive changes, roll that into a report with the ability to present as well.
Sure.
And then I think the one thing that's hanging out there is the date of the report itself and to what body. You could keep it as October 1st, 2025. I mean, Justice Oversight is a standing committee over the summer, could be a reporting body, but this is kind of on the outskirts of sort of, I think, the committee's jurisdiction on that. So,
I think so. We'll do it. What, the Senator Lewis, do you want to make a comment?
I was just wondering why we can't take a look at it with the edits on Tuesday and vote on it Tuesday.
Well, we can decide to do.
Okay.
Well, Kiki's gonna put down
It's a busy week.
review,
It's a heavy.
markup and possible vote. That's how it'll be worded. Right,
I mean, on the floor.
I mean, it's really to accommodate any oversights that I make, so.
yes. So he's gonna bring us a.
Right.
So, October 1st, 2025, is that,
Yeah, that's the suggested
so
time.
that's what the recommendation is that
Right.
too far out for the rules, or is that acceptable for the report on what you might be doing for the rules? Because these are not rules, remember, this is a report, so it's preliminary to the rules. Can we get it earlier than 2025? I mean, October could be January 15th, 2025.
Be a status report, where we're at in January 2025.
Okay, all right, and then a final. Okay, we'd like an update. This is an important topic for us right now. Yeah.
And as I think about it, you could do the status update, you could have the report submitted October 1st, and then you could probably include language that once the session begins, DCF can come in to explain the report or present it.
Yes, and 2 committees of jurisdiction.
Yeah.
That's good. This keeps it on our front burner. If we don't do this, it just the burner gets turned off. I don't want that.
Understood.
Okay, I know, you don't want to be on the hot seat, but we need to have that. That's good. Okay. All right, committee, that sound acceptable? Okay.
Sure,
Good.
all
right.
good. We love reports.
Yes, we do. We wouldn't be here without them. All right, thank you all. This is helpful.
Thank
So
you.
we'll, let's take a